Hello friends, today's topic is about magistrates cannot dispose of certain cases or certain cases could not be tried by magistrate. It is under section 322 of CrPC. 322 CrPC says which cases should not be tried by magistrate. When a case will be started by a magistrate by taking evidence, leading evidence or recording evidence, and during course of trial when the magistrate come to conclusion that that particular case should not be tried by him due to some reason, he has to stop the particular case immediately, and by going through the evidence and other parts of the case like charge sheet or evidence, and going through the evidence which was being led by the prosecution, the court can come to a conclusion that this particular case is not supposed to be tried by him. This is under 322 of CrPC. Procedure in cases which magistrate cannot dispose of. Clause 1 says, if in the course of any inquiry into an offence or a trial before a magistrate in any district, the evidence appears to him to warrant a presumption, Clause A, that he has no jurisdiction to try the case or commit it for trial, or that the case is one which should be tried or committed for trial by some other magistrate in the district, or that the case should be tried by the chief magistrate, judicial magistrate. He shall stay the proceeding and submit the same with a brief report explaining its nature to the chief judicial magistrate or to such other magistrate having jurisdiction as the chief judicial magistrate directs. And clause 2 says, the magistrate to whom the case is submitted may, if so empowered, either try the case himself or refer it to any other magistrate subordinate to him having jurisdiction, or commit the accused for trial. This is with regard to magistrate court having jurisdiction and cases which are supposed to be tried by the magistrate court. And there is another provision which says, if a case that has to be tried by session court, and when the charge sheet is filed before the concerned trial magistrate court, and during the course of the trial, if something comes on record which is during the course of inquiry or evidence, leading evidence, that particular content of the chief examination is attracts some other section of law which is exclusively triable by session court, immediately the trial court has to stop that trial, and it has to transfer that particular case to the session court by committing that particular case, and the session court have to continue with the trial. That is a separate thing which session court has to do. What it has to do, it will go as a procedure of law. This section is 323. Procedure when, after commencement of inquiry or trial, magistrate finds case should be committed. If in any inquiry into an offence or a trial before a magistrate, it appears to him at any stage of a proceeding before signing the judgment, that the case is one which ought to be tried by the court of sessions, he shall commit it to that court under the provision here before contained shall apply to commit. This is the at any stage of the proceeding. That is the main important point. At any stage when the matter is pending before the magistrate court, if the court finds or evidence is brought on record that which is that particular content of the evidence is attracts with regard to the sections which has to be tried by session court, the court has to commit that matter to the session court. This is this section which says the procedure when after commencement of inquiry or trial, magistrate finds case should be committed to session court. And this is the main important two sections which are very much important with regard to trial of any case. If a magistrate court is trying a case and it finds there is no jurisdiction to try that particular case under 322, it has to transfer that case to the concerned jurisdiction court or the additional chief metropolitan magistrate, whatever be the jurisdiction court. It has to immediately transfer that case under 322. And with regard to 323, when the trying case or the magistrate courts find during the course of trial or when the evidence is led before it that particular offence or this sentence which were being brought on record through chief affidavit, those will attract session court triable sections, then immediately the court has to stop that case and let the case be at any stage. The case supposed to be transferred to session court by committing that particular case. These two sections are very much important with regard to transfer of cases, or when new evidence is led by the witness before the trying court like magistrate court, and the subject matter which was brought on record or the evidence part, it is exclusively triable by session court. The court has to transfer that case to session court. These two sections are very much important in criminal procedure. So thank you for watching my video. Thank you friends. My name is Srinivas Advocate.